prior to 2001, a lot of federal immigration law was really bipartisan in nature. But after 2001, immigration becomes a topic somewhat like abortion, right? That is, once you say the topic, you can tell where people fall on that spectrum by virtue of their political party affiliation.
Professor Gulasekaram, how did the roles of state and local governments become such a hot topic in the opening years of the 21st century? Like, I remember 20 years ago, 17, 18 years ago, state involvement became really in the news, even not even in sort of academic circles.
Yeah. So, important to note that there has always been some level of state and local involvement. Much of the immigration that we understand today is a product of post-1965 changes to immigration laws. It's underneath those laws that people like you and me got to the United States. Probably.
Yeah, amen.
So, those laws opened up immigration to the entirety of the world to come to the United States, but they also started enacting restrictions on the numbers of people that could come from all the places, all the countries around the world. Now, as you can imagine, this opens up immigration for places that previously could not get in the United States. But on the other hand, the numerical restrictions really operate to restrict what had been routine migration flows from countries from which there had been geographic and historic relationships. For example, Mexico, which had often had people coming to the United States cyclically. And so it's post-1965 into the early 1970s that the idea of the unlawfully present immigrant in the ways that we understand it today really starts to take root. In the 1970s, California was actually the first state to enact what we might think of as an anti-immigrant law. It was a California law that criminalized the unlawful hiring of people who were not authorized to work. It gained significant notoriety. It goes to the Supreme Court. It was upheld at that time, but later the federal government starts to regulate in that area, and so laws like California become what's known as preempted. That is, the federal government regulates in that area, and state laws are can no longer be enforced. Also, during that era,
even if the state law is indirectly affecting that area.
That's right. So this is known as preemption doctrine. It's a function of article of the original Constitution, which tells you that the Constitution of the United States and federal laws are supreme over other forms of lawmaking, including state lawmaking. And this has been understood by the courts to mean that when the federal government enacts laws, it can preempt state laws. That is, it can exclude state laws, even state laws that happen to be similar to that federal law, even state laws that are serving the same purpose of that federal law. And this is essentially what happens with California's initial attempts in the 1970s to regulate unauthorized employment. At that same time, Texas attempts to exclude unlawfully present children from attending public schools. This becomes the famous Supreme Court case of 1982, Plyler versus Doe, still a very important part of our constitutional framework, in which the court says it is unconstitutional for states to exclude unlawfully present children from attending public schools in the United States. So I don't want to suggest that state and local involvement is just a factor of the last few years. And then again in 1994, California enacts its Proposition 187, which at that time gained significant notoriety. California attempt to exclude unlawfully present non-citizens from access to any social services and other types of state benefits, struck down by a federal court and later superseded by federal enactments in 1996. But I think one can fairly characterize all of those as, in a sense, isolated or low-level attempts to, obviously California is a huge state, Texas is a big state, but they didn't they didn't, I think, capture, other than Prop 187, capture the national attention in the way the state and local immigration laws of the last 10 to 15 years have. Post 9/11, post 2001, state and local immigration laws, as you rightfully say, start to gain significant national media attention. They start to occupy a significant part of federal dockets in terms of litigation. And we still talk about them today, right? What is the role and what's the appropriate leeway for state and local regulation? And that's even being tested as we speak by states like Texas and Florida, which are enacting these sorts of laws. So your question was, what accounts for this rise? And I think there are several different responses. A co-author of mine and I, Karthik Ramakrishnan, who's a political scientist at University of California, Riverside, were interested in this question. And one of the things that we saw was that prior to 2001, a lot of federal immigration law was really bipartisan in nature. They could be enacted in times of divided federal government by one party controlling Congress, but another party controlling the executive. That's a description that is accurate from 1965 through 2001. But after 2001, immigration becomes a topic somewhat like abortion, right? That is, once you say the topic, you can tell where people fall on that spectrum by virtue of their political party affiliation. So you get significant polarization, which leads to federal stasis. No federal immigration law to speak of really since 1996, right? It's a very long time. We're now going 30 years from that moment. And this leaves the opportunity for states and localities to really become robust in their immigration regulation. And it's also at states and localities where you're more likely to find pockets that are more closely controlled by political partisans, right? Where you can get enactments based, by pushing it through, a red state where the legislature and the executive are both controlled by the same party, or a blue state. And so you can get these sorts of enactments. That is one explanation for why you start to see a significant rise in them after 2001. And certainly with regards to, with the federal policies that are enacted during that time, states becoming much more robust in their attempt to push back against that federal policy by the use of state and local immigration policies.
In this discussion of 21st century states' involvements in immigration, I've seen the year 2012 mentioned several times, including your own writings. What happened in 2012? Was there a shift?
Yeah, it's a great question. 2012, I think, was a very important year for state and local immigration lawmaking. And you had a couple things happening all at the same time. One is that's the year that the Supreme Court decides a case called Arizona versus United States. And in this case, the Supreme Court strikes down most, but not all of Arizona's SB 1070. SB 1070 in Arizona was a state-level immigration law, an omnibus immigration enforcement law by the state of Arizona that attempted to regulate unlawful migration into the state by criminalizing several aspects of immigration in the state, and then empowering state and local authorities to do things like check people's papers or arrest people on suspicion of being unlawfully present in the United States. So in the summer of 2012, the Supreme Court strikes down many of those provisions in SB 1070. It's also the same summer that President Obama, nearing the end of his first term, institutes what's now known as the DACA program, right? The Deferred Action Without Arrivals program, providing some relief from removal for hundreds of thousands of unlawfully present young people in the United States, and providing them the opportunity to both go to school and to seek employment in the United States during the time that DACA is active. So I think those two are just significant things that happened at that time. And at the time that Arizona had enacted its laws, it wasn't just Arizona. There was copycat legislation in lots of different states, including Georgia, Alabama, Indiana, Utah. A lot of states had that type of legislation. So it wasn't just one state. And so that's why 2012 happens to become a very important marker. It's also a time when you start to see progressive or integration-minded localities and states start to mimic the same strategies as restrictionist or anti-immigration states. That is, maybe they start to think maybe it's a good idea to look at the possibilities for state and local policies that can be, in their view, more immigrant friendly. So that's when you start to see a rise in, for example, driver's license laws that allow access to driver's licenses or IDs to people regardless of immigration status, access to higher education, or education financing, professional licensing policies in states that allow people, regardless of immigration status, to become licensed as doctors or as lawyers, right? And so you start to see all of these movements happening and really accelerating in the 2012.
So that's why you call them integrationist. I'm not pronouncing it. These states are the reverse of states that were restrictive. They're passing legislation towards integration, right? Sort of the other side of the pendulum.
That's right. So you start to see both of these movements trying to use state and local jurisdictions and state and local authority to enact their preferred vision of immigration. Integrationists, or it's just a term other people might use other terms, but at least in my book and my co-authors and other people, you might think of integrationists as a set of policies intended to be ameliorative or pro-immigrant, to not worry about immigration status or unlawful status and simply treat people as residents of a community or of a state. And then on the other side, restrictionist or anti-immigrant, if you'd like, policies that attempt to be more enforcement heavy to deter the presence of at least unlawfully present non-citizens, and in some cases, all non-citizens from being in a locality.
And of course, all of this falls into the ambit of politics, where each state is. Let's take a break here. Stay with me and Professor Gulasekaram as we get into the perspective.